Okay, thank you, and thank you for the introduction. I think there is nothing left to say anymore, but it goes without saying, of course, that it's a great honor to be here, and I have the most responsible, I think, task to be in time with my presentation before the discussion and the lunch. As a professor of European Union law, I would maybe focus on something that was not discussed today. I think I just have to click, yeah. We all know that maybe this is something refreshing for our American colleagues, but that there is a European Union and there is a principle of supremacy, which is a cornerstone of the European Union. And what I claim actually with my presentation, that actually the fact is that 80% of the legislation in Estonia, at least, I think also in other countries, comes already from the European Union level. So this is almost everything. But what I claim is that Estonian lawyers and Estonian judiciary are blindly following. They are very dogmatic, ultra-positivist, if I may say, in applying European Union law. And this is also a moral question, actually, whether to serve citizens and the community, or to be, let's say, good boy, good member of the European Union. So what I say, there exists claimed constitutional interdependence between the EU legal order and the domestic legal order. I think in fact this is only one-way influence in many countries, and I would refer to Estonia. So what I also say is that also again talking to our American colleagues, that there has been a crisis in European Union, and I think that the crisis in EU has been predominantly a legal crisis. Actually, we are talking about economic and political and the crisis of trust, but the fact is that now, as the European Union is trying to create some kind of crisis mechanisms and save the European Union and the Eurozone, these mechanisms actually are not regulated by European Union law. They stay out of the EU legal system, and this also creates a new moral dilemmas for our judiciary and lawyers. So I would like to refer to some German philosophers, legal philosophers, Carl Schmitt, but very quickly I would just say that maybe if we take this philosophy, we may conclude that the supremacy shouldn't be taken as dogmatic. It is rather primacy of European Union law, not the supremacy. And I also say that the EU law can be supreme, but it should still be analyzed critically to serve the best interest of the community. So is there really a dilemma if we say that we are members of the European Union law, and as one of the commissioners said, well, you yourself wanted to be a member of European Union law, so you are here, so why do you complain? It has been determined that really the Central and Eastern European countries are more willing to obey the European Union law, and if to see the statistics, I think we are really the best. You know, the Poland, Estonia, Lithuania, Latvia, we do the best. But at the same time, we have big social problems. very big social problem. So there are kind of two worlds. The EU membership is not only that the government is doing something for the European Union or trying to implement something, but the one aspect is I think ignored, maybe not completely, but still ignored, that how to use the European Union law that would serve the citizens of European Union country. And well, we are trying to provide very pragmatic EU-friendly solutions, but if to see, for example, Estonian court practice, then and I know from the lawyers that if a person or a company goes to the court and tries to implement the rights that he or this company has from the European Union law, then the judges usually reject this argument. Say laws. Let's see first what we can do with Estonian law. So what I say is that judges are afraid to touch the European Union law. That is actually the most influential, because also the Estonian laws are made or are composed on the basis of European Union legal norms. So what I say actually in my research, and I've been in Estonian Parliament, and I'm also a member of the Committee of Legal Policy of the Lawyers' Union. What I say is that the rule of law must be followed even if we are in the European Union. There are also famous theorists like Chalmers and Tompkins, famous theorists who say that we try too much. It is kind of proved by the statistics that Estonians are eager to disregard the application of national laws, and we just take the EU legal norm and let it to be overruled. For example, the Lisbon Treaty, the latest achievement of the European Union, was ratified twice. So. Because it had different names and needed some corrections, but it was no problem for Estonian Parliament. 100%, yes. No discussion. This is not maybe a big legal problem as such, but legal political problem. In the center of this discussion is the Constitution. It's always the Constitution that mediates actually the supreme international or European whatever law to the domestic legal sphere. And we ratified, we actually accessed the European Union, and there was a protection clause. We said we obey the European Union law only if it is not contrary to the basic principles of Estonian constitution. The problem is nobody knows what are these basic principles. They are undetermined. And I give you some problems, just some problems. The EU is screening the practice of every member state every year. They give a report. Okay, Hungary is doing better now. Estonia is doing well. You know, they are pretty positive actually feedbacks, and I think they are positive because we are giving them inadequate information. This is the government actually, which has a special committee. And I was recently in Brussels meeting with the commissioners, and I asked about this and that. This information that they get is totally inadequate. Another problem, I see directives that are actually very much related to citizens. they are not communicated to the citizens. They don't know the rights, or they are miscommunicated. The EU law seems to be something very threatening. Not better, we don't touch it. We somehow deal with, we take our own Estonian laws and then we try to solve the issue. And as an EU lawyer, I would say there are huge possibilities. For example, judges can actually determine the compensation. There are no limits, but no judge would use it, because this is something that is related to state budget and well, it's a political question. There are many examples where we blindly adopted even the soft law of European Union. For example, the Code of Conduct for European lawyers, which is not actually with binding character, but we made it to be binding. It's also the case of, if you see the last line, the Bologna system in education, which is the declaration. But Estonian minister, pushed it through that it would be with the status of legal regulation. So there are many colorful maybe cases I would bring to you, but as a lack of time, maybe I just point out some of them. For example, the competition law, the core how to say issue of the European Union common market. Well, we apply, of course, the standards that are coming from European law, but there is no compensation for those whose rights were violated. So, for example, for Europe, it seems very nice. We apply all the standards, but we won't do anything for our community. So there is a famous sugar case. The very first day we were in European Union, Estonia got a very big fine from the European Union because we had too much sugar in Estonia, and it was against the European Union policy. I mean, there is the central agriculture policy is still very much regulated from Brussels, and what the lawyers said actually that it is absolutely it's absolute nonsense. We should fight to Brussels bureaucracy, and we didn't. Only now, 10 years later, we won the case because some other countries, were more encouraged to find the truth, and even more, Estonia lost the case against the enterprises because the enterprises in Estonia had to pay again the fines to Estonian government, who had to pay big fine to the European Commission. So maybe here I would refer to the Supreme Court, which is the highest court in Estonia. The case from 2006, sorry, 2006, that only grammatical collision with EU law is possible. Only grammatical collision. So I still believe that if there is a dialogue between member state judiciary and lawyers and EU level, then the outcome would be better for everyone, also for EU legal system. And what actually worries me that if the case goes to the Supreme Court, there are more and more cases related to EU law and implementation of EU law, then there are very many separate opinions. Like the last case we had about ESM, European Stabilization Mechanism. This is some kind of monster that allows or actually obliges the member states to pay money actually to, let's say, directly to Greece, yes. So there was a big debate, and first time the Supreme Court made it made a big show of that. The TV was there. I was also there. I'm cited in the Supreme Court judgment. You know, all the people who knew something about European Union law were there. All the ministries gave their opinions, and it was a kind of I think to lose the tension, because the tension is in the air, it is interesting that we had 19 judges, and 10 of them were for to be members of ESM system, and 9 of them were against. So it also shows that in a higher level, the judiciary has no like joint opinion. And even more, if you read all these opinions, they have all different angles. So what I say to our government and judiciary very often, we don't have the doctrine. We don't have the constitutional doctrine, and that influences a lot. I mean, the everyday practice of lawyers in a lower level, in every level. So this is the moral dilemma of every lawyer, to apply, or maybe to say how to apply the European Union law. So I skip these slides about the ESM. And I just maybe try to conclude with some comments here. So this eagerness to comply, to look nice for Brussels, I think this is priority. And this is a picture of our ombudsman, who has been actually elected second time. So I think he can be more flexible, and he raised this issue many times. He said that Estonia should not act as a good boy who fulfills all the tasks, the letter given by European Union, but we should be critical. And directives, especially directives, could be viewed upon a less restrictive, but rather to help community. So Estonian legal practice, just to conclude here, is that we are very eager to refer to international treaties and EU law even before the legal acts are adopted. For example, the EU Charter. Maybe this is not the best example, because I think the EU Charter is a very good one, but the judiciary holds this very dogmatic opinion that EU law is supreme, and this is the end of the story, that we will not discuss it, we will not compare it with national standards, it should not be further analyzed. And I remind you that 80% of legislation is coming from EU level. Well, we have many cases, and I maybe just refer to some. Case of Mr. Lauritz, who was unlawfully imprisoned in Finland for 9 months. And the lawyers of Estonia, they said, oh, well, this is the European arrest warrant system, so we will not mess with this. Let him be in Finland, and the European standards show us the light. But in the end, it was unlawful arrest. Or case of Mr. Piirsoo, who went to bankruptcy because there was a tax claim from Germany, and our lawyers said immediately, I mean, this must be implemented, and the company went to bankruptcy next day. So what are the alternatives? Is it protectionism? Is it like we are against the European Union? No, I would not say that. Also, if you hear the speeches of Mr. Cameron, you may think that this is the only way how to be in European Union. But for example, there are guiding principles for EU legislation in UK, and this is actually quasi-binding for lawyers who are working for the government. There is a constant political review in UK how the directives should be implemented. They are very carefully looking at how to implement EU law. and we call it obstinacy doctrine. So there must be maximum economic and political interest, wellness, for the country. And I think this is not maybe the right way. Well, you see, there are recent developments. We all know the cases from Karlsruhe, from German Constitutional Court. I will not discuss it today, but recently the Portuguese Constitutional Court made a very interesting decision, and it seems that in Europe there will be a discussion, especially in the context of possibly emerging federalism. So what are the solutions? I think that every member of European Union should identify what are the constitutional values, because the European Union also is based on the constitutional values of the member states. And perhaps it is time to really shift the sense of morality and rule of law from the sense of obligation to the supremacy. And as I mentioned, there must be a judicial dialogue. I very much hope that the new legal act, the EU Charter, would become a kind of valuable source of making ethical choices, not only in the EU level, but also in the member state level. So thank you very much. This is one of my, as Edita said, I have hundreds of books, but this is, I think, the book that would explain, this, my theory or my approach more closely. So if you are interested, please. And thank you for your time.